is my pleasure and my honor to welcome you to the first lecture of SepaRope, that is Separation of Powers for the 21st Century Europe. And this is a North-based project that we, the Amsterdam Center for European Law and Governance, are conducting together with the Eric Kastrin Institute of International Law and Human Rights in Helsinki and the Center for European Research at the University of Gothenburg. My name is Christina Ackes and I'm leading this project in Amsterdam. And of course, I'm extremely pleased that I can introduce to you our first speaker, Christoph Möllers, who is Professor of Public Law and Jurisprudence at the Humboldt-University in Berlin. He was fellow at NYU School of Law and the Wissenschaftskolleg zu Berlin. But most importantly, and this is why we are so happy to have him as our first speaker in this series, he wrote the book, The Three Branches, a Comparative Model of Separation of Powers. And today he will speak to us about the place of majoritarian politics in the concept of separated powers. Without much further ado, Christoph, I would like to invite you to take the Zoom screen, I guess.
Yeah, well, thank you very much for the invitation. When I was invited, I was actually still hoping to come to Amsterdam, but it was already only a hope. And now it's clear that I'm here sitting in Berlin and greeting you all. And still, thank you very much for the invitation. Yes, I want to talk about majoritarian politics and the concept of separated powers. So I will not really give you a theory of separated powers or something, but I will somehow build on the concept itself and wonder what we can do with it, or what politics in a majoritarian sense actually means to it. So that's my plan. I want to say a little bit about reasoning and counting as a stat. You will see what that means. Then I will give a little introduction in what separation of powers is actually about. Then I want to say something about simple majority decisions, which are in a way the core of politics, of democratic politics. And then I want to show two research paths. So what do we do with that, and where are angles to apply that? This is not a theory, and that is not something I've really thought extremely deeply about. It's something I'm now moving into, and in a way as a complement and as a further development of what I've been doing with regard to separation of powers theory. And so this is not really, it's a work in progress, and it's still, you know, something we can, everything is somehow fragile and has to be thought about again. Now, we look to the United States at the moment, and we see, you know, we see people that we see counting. And they're counting votes. They have now, I guess, stopped to count votes. They have come to a conclusion, but still, this seems to be something quite elementary with regard to the democratic process. And I think the beauty of majority politics maybe lie in the formality of that counting. So counting is a very simple form of truth criterion. You know, you have votes and you have formalized votes. You count them, and at the end of the day, you wonder who has gotten more votes. Obviously, there's much more into that. There are electoral systems in it. There are many decisions before the counting starts. Still, it is, when we get to that point, quite easily to say we have something that, like a generally accessible truth criterion, which is very complicated to contest. So when we look at what is going on at the moment, where President Trump tries to contest the results of the presidential election 2020, you see he has a hard time to do that, because the general evidence of what has been counted seems to be so overwhelming and seems to be so clear that it is very hard to make something, do something meaningful against this. Now that is interesting, I think, because much of democratic theory of the last 50 or so years was very much interested in deliberation and rationality and the, in a way, rational virtues of the democratic process. While the counting, in a way, and the empirical virtues of the democratic process somehow got a little bit forgotten, it seems to me. When we look at Habermas, I quote, I think something, some private exchange, he said, you know, basically majority vote and counting is merely empirical. You know, it's not about truth, it's not about rationality, it's not about deliberation, it's just something, you know, you do in a very simple way. And my point would be, yeah, and that's probably not advice, it's a virtue, because that in a way makes it, in its formality, very hard to contest and makes democratic access and democratic participation much more resilient to authoritarian and other challenges than, you know, a democratic deliberation. So the counter question would be, what would be the case if we had to rationally deliberate election results? You know, we would be in a political mess We would have, you know, an exchange of arguments that are very much mendable and flexible and open-ended, while the counting process in its simplicity is something everyone can understand. It's in a way generally accessible to everyone, and it's very complicated to contest, though it expresses the virtues of democratic equality. So with that in our backhead, I want to start the lecture and wonder about, so what does that mean? Majority voting, and counting of votes, simple majority decisions for the theory of separation of powers. Now, my first part would be a reminder of what actually the whole theory is all about. And this is something I'm a little bit drawing on my book. And if some of you have read it, it's an honor to me and helpful, because this will be very short and in a way quite dense. So the point of the whole book is in a way to say, you know, separation of powers is not confined to legalization and control of public action. It's not just reviewing public action, binding it, legalizing it, reviewing it, but it's also about a principle that has to enable political contestation, political action. So we cannot really confine separation of powers to, you know, the judge who is reviewing something or the board that is controlling something, but there's something that has been reviewed or has to be reviewed. The action, the political a decision that has been made is in itself a product of separation of powers. That also means we have to connect in a legitimate model of separation of powers, law and politics, in a way that politics is not somehow the unknown quantity that somehow has to be tamed, to be legalized, to be reviewed, to be somehow put into some legal cage, but it's also the product of separation of powers, you know, that has been gone through a legislative process, to electoral contestation, to party politics and all the other things that belong in a democratic constitutional system to a political process. So it is very important to see that, because I think we have still a very strong tradition, and by no means accidentally pushed by lawyers, that somehow has this priority of law over politics, the priority of review over action, the priority of, you know, the control mechanism over the, you know, open, undefined, you know, will formation that is very much dominating textbooks and discourse on separation of powers, which is very much dominating the whole tradition of constitutionalism. Somehow forgetting that constitutionalism is a product of a revolutionary tradition that somehow wanted to empower political process at the same time as, you know, confining it, controlling it, and formalizing it. And these two sides of the equation, I think, are very, very important to see when we get a full-blown and somehow theoretically satisfactory concept of separation of powers. And that means that legislative and executive and judicial actions represent always both law and politics, and I will come back to that. There's always politics in all of them, though in their respective specific procedural manner. So the difference between, let's say, judicial action and legislative action, and we can talk about the definition, I won't get too deeply into that today. The difference between them is maybe that they in themselves have different contributions of law and politics to their respective action, but it's not that there wouldn't be both present in all of the three branches. So there's always something political in judicial action, and there's always something legal, formalized legal and legislative action to function in a legitimate and somehow satisfying manner. And the clue of any separation of powers theory is then to somehow define the specificities and the distinctions. The question, why is the judicial process of lawmaking so different from a legislative one, and which are the criterion to distinguish them, and which are the virtues, the organizational virtues that they express in their specificity. Now, that also means there is a legitimate place for majoritarian politics within separation of powers, and probably in all the three branches. And I will come back to that in a second. But in a way, what I want to keep for the first point is in a modern and I think somehow enlightened concept of that somehow gives, you know, democratic process its right. Separation of powers is a theory that has to have a positive account of politics and cannot only refrain itself to, you know, taming and limiting it. It has always this enabling side too. So when we now come to simple majority decisions, SMDs, as I call them here, I think we have to, let me just go at the first point to a little bit of theory about decision theory about what is actually the legitimate virtue of separation, of simple majority decisions. There is a seminal paper of 1952 by May about what do we actually simple majority decisions have for. And he gives, the formalized argument he makes is that only simple majority decisions can guarantee 4 conditions, and 2 of them are interesting for us, and I will come back to that. The first means anonymity, and anonymity is his word for equality. It means that every participant has the same input into the decision-making process, or differently put, that whoever you are, anonymous, your vote will be counted in the same manner. The second, I think the most important for me today, is neutrality. To say only when we have a simple majority decision, we get a procedure that is neutral to the outcome. So that every possible outcome, every possible intervention is somehow equally valid and equally possible within the decision-making process. That is interesting because behind this, there is a whole political theory of the question of state intervention and neutrality, because we can say that when we take the status quo as in a conservative concept to be somehow normatively valid, then we would probably not go for a simple majority decision rule. If we take the status quo not being, normatively more valuable than any other possible status quo, then we would have to go to a simple majority decision rule, because then we need a rule that is neutral to the possible outcome of the decision given by, let's say, a legislator or some other branch. The other 2 is decisiveness and responsiveness. I won't get into now. One is about, the question that there must be an outcome at all. There must be a decision at the end as a condition for decision-making rule. And the other one is that, changing votes must somehow lead to some reaction in the result. That is not so important for us. Maybe self-evident. It is not really, but it's not for me today to go deeper into that. Now, when we take that, then we can say that given that criteria, simple majority decisions create something like collegiality and horizontal organization, the organization of the decision makers through the criterion of anonymity. So what we get is a college of equals through a simple decision-making rule. And it creates something like collective freedom, and Kelsen already saw that in his Allgemeine Staatslehre in 1925, through the fact that, we are now free to make any form of decision simply by finding a majority, and not privileging any form of status quo, and not privileging, in a way the world as it is, but instead of that, somehow having a rule that allows us to make changes as easy as possible through this only possible procedure that guarantees neutrality with regard to the outcome. And therefore, at the end of the day, simple majority decisions create something like formalized politics. When we can see wherever you have a simple majority decision rule, and this is not about legislators, it's basically about every board, every college of peers, of equals, you get something like a micro-political process. And you get a logic that is somewhat different from decision-making logics you have had before. Now, what does that mean for separation of powers? I think it is very important now to see that seen so abstract, and with such an abstract model, you see that simple majority decision rules are somehow ubiquitous within every system of separated powers. Obviously, you have something like simple majority decision rules in parliaments, and I won't really come back to that because that is the self-evident case. But you also have it in courts. Most courts somehow count votes in decision-making bodies, from the United States Supreme Court to any court that is not constituted only by a single judge, and most upper instances at least are designed like this. You have a simple majority decision rule. You don't have that everywhere and always. You can have qualified rules, you can have other decision-making rules, but this is a very regular and not a rare case to set up a decision. And the same can maybe said, but to a lesser degree, and with regard to executives. Always you find at least executive branches. There are not so many, but you find some of them. And that in itself is quite remarkable, in which you have simple majority decision-making rules. You have had that for a time. It's a little bit contested how that really worked out. with regard, for example, to the cabinet in the English constitutional system. You have that partly in the EU council system, and you often have that in deliberative bodies and agencies, for example, with regard to the ECB Council. So there you have this kind of rule. And that means you have something like a majoritarian micro-political processes in many parts of organized public authority beyond the standard case of parliamentary decision-making. And I think that is something that is really underestimated. And with regard to the analysis of decision-making, it's quite clear for, economic theory, decision theory in the classical sense, but it's not so much a subject, has not so much been a subject in separation of powers theory coming from constitutional law or political theory. Now, let's take one moment step back and think about the case of qualified majority decisions, because obviously, especially when you do constitutional law, but also when you do European Union law, qualified majority decisions are a very important element of constitutional setup. So what about them? Now it's interesting to see that they also create something like collegiality. So they create a political process within the members who have the right to vote, and they also create equality. So also in the process of qualified majority decision making, all the members that have the right to vote are treated equally. So they are a college of equals. But what they don't do is actually, they don't produce neutrality, because you need actually more than the simple majority to make a decision that leads to the vice versa, to the conclusion that the status quo is actually a privileged to the possible change you do via decision making about, let's say, some legislative act or something else. So that means qualified majority decision create a political process that is, in a way, that is a process under equals, but that is not a process that is per se neutral in the sense May gave in his seminal paper on decision-making theory. And that means that for the college itself, for the collegium that makes the decision, we have in a way a disempowerment of the college towards its members. Its members become more power because every one of them has more of a veto position towards the college that makes the decision. It's harder for the college to get to a decision. And we see something like a disempowerment of the college towards the status quo. That is what is meant by neutrality. And because the status quo is the more probable outcome when we come to a qualified majority voting rule. That is interesting because, and that is something what we have obviously discussed under the heading of the counter-majoritarian difficulty with regard to courts, but it's also true with regard to any other elements. That obviously means that we have a quite ambivalent relation between democratic constitutionalism on the one hand and constitutional supremacy on the other hand. What I want to say with that is that when we take democratic constitutionalism as a constitutional order that establishes a rule of equals, democratic equals, that is somehow necessarily connected to a rule of simple majority vote. And when we, on the other hand, think of constitutions as something like a supreme rule, a rule that enjoys some kind of supremacy or priority, then we normally connect this supremacy with the qualified majority vote, qualified standard rules to amend the constitutions, qualified rules to establish a constitution, and so on and so forth. And this somehow sits uneasily together, I think. The definition of the order as democratic on the one hand, and the other, and the necessary connection of constitutional supremacy with some kind of qualified decision-making rules. This is obviously no problem. We see that when we look at the history, for example, of the American Constitution, that people like Thomas Jefferson, for example, always felt uneasy about the fact that the amendment of Constitution is such a difficult thing to do, and found it somehow necessary to renew constitutions every generation to get something like a fresh democratic legitimacy for to start anew with any given political order. But we somehow have abandoned this intuition towards a rather, let's say, a concept that is more interested in the supremacy than in the democratic effect of it. But still we can say there is a lack of what the decision-making theory would call neutrality when we look at the phenomenon of constitutional supremacy. Now, what does that mean with regard to research? And I'm already coming to my third part here, to research. So what can we do with that? I want to show you in at least two ways in which research could try to connect decision-making questions and question of the legitimacy of majority on the one hand, and classical problems of separation of powers on the other hand. I think it's at the start important to see that separation of powers always has to take care of both, of inter-organ and of intra-organ perspectives. So classical separation of powers is very much about delegation, about judicial review, about parliamentary control, about the relationship between, when we talk about the international, supranational level, of member states to the bodies they are constituted of, or even of the relation of intergovernmental to supranational organs. This means classical separation of powers is somehow mostly an inter-organ discourse. You know, what is better, presidential and parliamentary systems? What is best? Which decision-making would be better? What can the Parliament control? European Parliament review the Council or only the Commission? What does that mean? And so on and so forth. Many open questions. But it's important to remind us that this all only works because we have some really strong intuition about intra-organ procedures. In a way, we have to look at intra-organ procedures even to define some organ as being legislative or executive, or somehow perhaps hybrid, you know, and we have to look at the procedures within organs. And here, I think my point would be, we should be more interested with regard to majoritarian procedures within different non-legislative organs. So we should somehow take our perspective into procedures within organs that are not classical legislative organs, but which have their own little political processes, their own little majoritarian politics. That is not the big majoritarian politics of, you know, elections and parliaments, but which has its own functioning and maybe even its own dysfunction, and which is very relevant to somehow get a grip on the legitimacy and even the functionality of these organs. Now, when we take the two perspectives, what can we do with them? Let me just give you two examples. And let me say, before I do that, that the relationship between both perspectives is not entirely clear. So when you look at the literature of separation of powers, both elements are not always quite clearly connected to each other. Sometimes the question how a parliament works, for example, is just taken for granted in order to make a case for parliamentary review. Or sometimes the idea what an executive somehow is actually constituted of is taken for granted in order to make a case for or against, let's say, an executive prerogative in external affairs or something else, what has been debated in classical separation of powers. So I think the connection between the intra-organ and the inter-organ perspective is very important for any good theory of separated powers. So we have to describe what the organ, how the organ is actually functioning before we make a case for how it should relate to another organ or to another branch. But especially, and that would be my point here today, we should look into these into these relationships, into these organs with a special interest in, is there something like a specific micropolitical process going on within the organs? So let me now take two examples. One a little bit more big one, a speculative one about a thing we are all discussing at the moment, and two very short, just mentioning them. We can perhaps talk a little bit more in the discussion then about intra-organ perspectives. Now, with regard to inter-organ, so the classical separation of powers relations between different organs, I think the perspective on majority and the legitimacy of simple majority rule could perhaps help us to get a different way of describing phenomena of authoritarian constitutionalism. Now, we're having a big debate at the moment about Hungary and Poland, for example, within the EU, and we mean some, let's say, liberal constitutional lawyers at least, and liberal political scientists seem to agree upon the fact that there is a big problem with regard to Poland and Hungary. And I would make that case very explicitly. But the question, what we're actually describing here, how the problems actually is spelled out, and how we can describe it in order to make sense of it as lawyers or as political theorists seems to me not entirely clear, and seems to be an interesting application of what I've said about the legitimacy of simple majority decision-making rules. Why is that so? Well, you know, very often what is going on in Poland and Hungary is somehow described as something like a tyranny of the majority. So basically you have a majority, the majority comes into power, votes for Orban and Peace Party, and then they are somehow screwing it up in an authoritarian manner. And that somehow seems to reflect an old anxiety of liberal political theory, spelled out first by Tocqueville and then very influentially received by John Stuart Mill, actually to say, you know, majorities can be tyrannic. Now, there's a lot to be said about what actually Tocqueville was meaning when he said this. I won't get into that, but I think there is a problem with that kind of reconstruction. Why is that? So no, I think because when we look at what actually has been going on in Poland and Hungary, we can say that at least parliamentary majorities, and we talk only about parliamentary majorities because these parliamentary majorities are, by the way, not necessarily the product of electoral majorities. So there's a lot of going on in the electoral side of that. I want to get into that. But even when we take parliamentary majorities, they seem to be both constituted by simple majority decision-making rules as well as undermining simple majority decision-making rules. So why is that so? So what we see, especially in Hungary, is obviously a lot of constitutional entrenchment of authoritarian policies. So on the one hand, people like Orban somehow claim to be in the majority, but on the other hand, they don't really trust simple majority rules. So they want to make sure that their implemented policies will survive even when there is a majority that differs from, let's say, Fidesz opinions on certain kinds of decisions. And what we also see in both countries is that there are a lot of institutional obstacles erected that somehow prevent simple majority decision-making rules from actually becoming operative. So all the things that we see with regard to tampering, with electoral review in Poland, but even things like media liberties, freedom of the press, and so on and so forth, they all seem especially directed against a system that allows simple majorities to come into power and to change the course of the political process. So that means, I think, to me, that we cannot define authoritarian constitutionalism just as an intrusion of illiberal democratic majorities into something like the rule of law. That is very much the reading the Commission has been giving to that. That is very much the thing that the European Court of Justice is interesting in with regard to independence, very much more careful and not very much more reluctant with regard to media liberties or other things, that they really stress that point. But I think it's somehow incomplete, maybe even wrong, because the final aim of all these seems to be that the powers that are, the governments that are in power somehow try to insulate themselves in the middle or in the long run from majoritarian politics. So there is a majoritarian pedigree of that, but there's also an aim that prevents future majorities from becoming operative and from changing course and from somehow refraining from the illiberal policies that have been implemented, at the moment implemented in both countries. And that follows the old Keynesian tradition, I think, to say perhaps we should read Article 2 of the treaty. This hodgepodge of values, a very badly crafted norm, actually, as being a norm that is, whose meaning is actually to protect future majorities and protect the integrity of a process that is, at the end of the day, a process that is very much leaning on simple majority decision-making rules with regard to electoral laws, but also with regard to parliamentary majorities. So what we get is at least an ambivalence, maybe more, with regard to the questions, where is actually the problem in Poland, Hungary, and how do we understand the somehow fuzzy notion of European values we are protecting against these two countries? I think we haven't been, there's no much more literature coming out, but one of the tasks we have to do is actually to make some systematic or critical sense of what Article 2 is actually about. And for me, it seems to be a bit short-sighted to follow that liberal script of tyranny of the majority and say, you know, it's only a rule of law problem. What we see is that all these institutions somehow make use of simple majority decision-making rules in order to be legitimate. And if that is the case, then we have to wonder how we somehow implement that in the reconstruction of the problem. And my argument would be that at the end of the day, what we observe in both countries is a case in which, by referencing to their own majority, some are preventing future majorities from becoming politically relevant. Now, that is the first path we could talk about, we could think about. That is the classical inter-organ majoritarian processes. Now, the second would be intra-organ politics. So the question, what kind of politics is going on within different organs of states or the European Union? And again, I want just to give you two little examples. The first would be obviously the Court of Justice of the European Union. So just one example, it's not the only one we could really apply, but what we see is that Article 253 of the TFEU provides that the president of the Court of Justice of the European Union is being elected by the judges or the justices of the court. Now that is very interesting because we have only but quite firm anecdotal evidence about these elections, which are obviously full of policy elements, full of deals, full of promises, and so on and so forth. We don't really know so much about that, but we hear stuff about that, and we get a little bit into research now about this. We have some empirical and a lot of anecdotes because of that. But what we can see is that what we can at least take to be sure is that there is something like a political process going on, a power political process, which has to do with many elements that are not necessarily elements of the law. It's obviously about member state pedigree. It's about a vision of European laws being more or less unifying. It's about, internal politics of, more or less relevant judges or justices that somehow want to get assigned to certain cases or don't want to get assigned to certain cases, and so on and so forth. So what we see is at least that this creates a hierarchy within the court that is partly very formal. We know that the president has certain powers to assign cases and so on and so forth, but partly obviously also very informal because it's about different judges having different degrees of influence on the will formation of the court as such. And what we also see is that courts are organizations that are, as any other organization, somehow have an administrative side. They are not just people or spirits who somehow decide cases according to doctrinal rules, but they are heavily embedded into a very complicated, complex, and in the case of the CJU, quite huge organization, and that somehow has to be managed. And we don't know really much, and we don't have any good theory, it seems to me at least, maybe I don't know of it, that somehow tries to connect questions of internal administration of courts, and especially of such huge and vast and diverse heterogeneous courts like the CJU, with questions of lawmaking and of doctrine. So now the aim would not be to debunk the court and to say, everything is politics. That would be vulgar and not really interesting. The aim would be to get a further grip on what this actually means. That, for example, the president is elected in a political process, what that means for the jurisprudence of the court and for the way the court makes sense of European law. That also we had to be much more interested into the internal rules and the internal will formation processes and within the CJU. Now, the same story can be told, obviously, with regard to the ECB Council. The ECB Council has decision rules that are very interesting. Obviously, the question who is represented how, big countries, small countries, capital doesn't play a role. That is quite remarkable in a way. And it also has obviously something like a relevance of member state pedigrees of its members. So we all know, again, only by anecdotal evidence, that there seems to be something like a south-north divide, that the presidents of, the Dutch and the German central bank may have different ideas of central banking than the presidents of the French, Italian, Spanish central bank, and so on and so forth. We have quite crude idea of how that works. We know that different from the Federal Reserve in the United States, the minutes are not published, which is a big problem in itself. So we get something like an arcane political process that seems to be quite relevant for the way decisions are made. And that seems also to be quite relevant for the way the courts, the legitimacy of the whole enterprise is somehow constructed. Now, when we look at this, I think the bottom line is that both organs in their respective ways claim some kind of rational deliberation. So the first claims to law and interpret European law. The second one somehow claims to be economically sound and have some kind of a model, empirically saturated model of fiscal policy. And if they had to choose a theory of decision making, they would not go for May. They would go for Condorcet's jury theory, and that basically says, the more deliberation, the more people involved, the better the decision. Something that probably doesn't really work for courts and maybe not even work for central banks. For we can get into discussion. But it's relevant to see that both somehow practice majoritarian politics. We somehow know that even if we cannot prove it. And it's also important to see that this might not necessarily be a problem. Maybe there is a virtue in the way we do that. Maybe there is even a virtue because we have such a heterogeneous polity behind these two organs. It's not the United States of America, it's not Germany, it's not the Netherlands. We must not forget that the European Union acquired heterogeneous and somehow complex to manage entity with a very uncertain political identity, in which these kinds of political procedures may have a different relevance and even a different legitimacy. So the claim would not be to look at these procedures in order to, as I said, not to debunk them or to say, this is not really law, this is not really fiscal policy. In truth, it's really bad politics. This would not be interesting. The claim would be to wonder how these processes actually work, how they spell out, and what they mean. First, for the actual working of these organs, but secondly also for their legitimacy. And that also meant for researchers and for people who do theory to devise more elements of such a theory and wonder about in which way political, intra-organ political procedures, the micropolitics of courts and central banks, for example, can contribute or not to the political legitimacy of that kind of organ. So what does that mean? And now I'm basically done the outlook. Now, I think, first of all, that is quite basic, but I still think we always have to be reminded of that. We should think of the legitimacy, again, think of the legitimacy of simple majority decision rules. Why do I say that? Because I think most of the most powerful philosophical constitutional theory that has been received in the last 50 years, let's name people like Jürgen Habermas or John Rawls, were always quite critical of simple majority decision rules, and somehow always wanted to trade them in favor of some kind of model of rational deliberation. And I think we have to just confront the fact that liberal democratic states and other supranational entities are built on these rules, even if the rational deliberation doesn't take place. And the reason for that is basically much more elegant, perhaps spelled out in the decision-making models of people like May that I quoted than in some kind of full-blown political theory of rational democratic deliberation. That also means that we perhaps, as a more abstract interdisciplinary research program, have a deeper look into the connection between decision theory on the one hand and traditional constitutional theory on the other hand. There is work, to be sure, it's not something new, but still it seems to me a weak link, and we should perhaps follow up that link in much more explicit terms. And that also would mean, as I said, that we have to have insights into the internal politicization of non-political organs. So non-political organs like courts and administrative agencies, especially, what kind of micropolitical procedures have them. And one point to start, as I said, is actually decision-making procedures that follow a majority rule, decision-making rule. And to have insights, as I said again, it does not necessarily mean to criticize them or to debunk them. It rather needs to give a more full description of what is actually going on. Then, and that would be my last point, that would at the end perhaps leave us to even more complex questions of political representation, because when non-political constitutional organs like courts and central banks and others are unavoidably applying micropolitics, then they are also unavoidably part of the system of political representation. And then we might wonder if we can really be satisfied with a theory that describes courts as applying the law and central banks applying sound fiscal economic rules. But we have to wonder in which way they participate in the general system of political representation, or to put it much more easier, whom they actually represent through what kind of representation rule. Thank you very much.
Thank you, Christoph. Thank you for starting off our lecture series in such an interesting manner, refocusing us on the politics in separation of powers, which I think particularly lawyers are prone to not give sufficient attention. Many thanks.